Great. Hello, everyone in person. We do have an online audience as well. So I just going to check we are ready to go with the online audience. We are doing an exciting hybrid event, but thank you very much to the hardy people who've turned up in person. Are we ready to go?
Yeah, they're just joining now.
Is it all right to take a couple of pictures as we go along, or should we wait till the end?
Maybe at the end.
Yes, I think that would be best.
You'll get better posts
Great. Are we ready to go? Brilliant. Good evening, everyone, and thank you very much for joining us at this launch of the CEDR 10th Mediation Audit. My name is Frederick Way, and I'm the head of the CEDR Foundation, and I'm really delighted to be tonight joined by my colleague Graham Massey, who is Chief Operating Officer of CEDR and also the author of the report. Just before we get started, I just wanted to do a bit of sort of housekeeping about how tonight is going to work so that everyone knows what we're doing, and also for our online audience as well. So, firstly, this event is being recorded, so you will be able to watch it afterwards if you'd like to, and we'll be able to sort of send it to everyone who's attending. What we will be doing is Graham will present the results and go through the main features of the audit. We will be releasing the audit actually in an online version tomorrow at I say 9 AM, hopefully it'll be at 9 AM, but everyone here attending and online will be sent a copy. So do not worry, you can sort of find it on our website, you can find it on LinkedIn, but you will also receive a copy. So there is no hunting that you need to do for this. You will get it. We're not producing physical copies because we are saving the environment by doing that. So that's sort of what we're doing. What we'd also like to encourage is, as we go through it, if you've got questions that you're thinking of, please do think about those, and we'll have an opportunity to ask some questions at the end. If you're watching this online, we'd ask that you please put them in the chat. That will go to the host only, and then we should also hopefully be able to have people in the chat asking questions. We're really interested to hear people's thoughts, so thank you for doing that. There isn't really much more that I need to say other than that, but just to say thank you for that, and look forward to hearing some more from Graham now about the mediation audit and what we've discovered.
Thanks, Frederick. Thank you. Well, it's good to meet you all. Thanks for coming in. There's one other thing to say, which we posted about an hour for this session, but I've got nowhere else to go, so I have to stay down. Thanks. I'm only supposed to be speaking 15 or 20 minutes. I'll probably talk for longer, but I don't have sign of the clock. I do have the bells outside. So if I'm still talking when those bells go, I will stop. I've gone on too long. So the mediation audit, I think I first did it in 2003, back in the day when CEDR used to run a big mediation conference at Queen Elizabeth Conference Centre every single year. And the purpose in the very early days was to provide some early proof points of the success or the progress that commercial mediation was making in these early days. And somehow I got stuck into a ritual or rut of repeating the exercise every couple of years. So we continue to track progress of the field. So some of the questions are the oldies and goodies, which have been around since the very beginning. But then in addition to that, every single year, we try to target one or particular theme. So I think last time one of the themes was diversity. This time, the theme, or the additional theme beyond tracking, is readiness of the field to accommodate the needs of mandatory mediation in terms of capacity and any other issues or challenges that mediators, lawyers foresee. So I mentioned lawyers because there's been two surveys. The primary survey is of mediators. We've had 328 responses from practicing mediators. They're not the usual suspects from CEDR, because the mailing list for this survey has gone out via CMC and also via many of the other subscribing members or providers who are associated with CMC. So we're sort of very grateful for the wider support that we've had for this. We've had input from the Ministry of Justice about some of the questions. So some of the things we've asked were things that they told us they're particularly interested in. We've also done a parallel survey of lawyers to get their views about mediation from the lawyer-client perspective. Probably fair to say the response rate we get from lawyers is not so good, but to the extent that and that's why I don't really publish the full results, There's a few cases where I'm at least able to say the lawyers agree with the mediators, so it's a little bit of reinforcement. So that's what this is all about. Why do we do this? As I said, it's to promote the field. Why do I do it? Partly, as I said, because I started off doing it. To be fair, I think I'm unique. I think I'm the only fellow of the Civil Mediation Council who's also a fellow of the Royal Statistical Society. So I can at least claim some sort of odd dual qualification. It's my credentials for the civil. So we start off, as usual, with the size of the market. Nothing's happening, guys. What it is. So 2 years ago, we had gauged that the size of the mediation marketplace was about 16,500 cases a year, split between those which were coming to service providers, those which were direct referrals to mediators, and those which were coming through organized schemes. We then went into lockdown in the pandemic, and that had a significant impact on the case volume. During the pandemic period, year to September 21, there was a 35% decline in cases. That was all reported last time around. So that's what the right-hand bar is there, a significant dip. There was also a massive move across to online. So an incredibly high proportion of cases were done online during that period. The good news is that since then, the field has increased back. So the year to September 2022, which I had actually portrayed in a report as post-pandemic period, though frankly, when I did my research on it, it's not recent. It's probably worth remembering that until sort of January, February 22, we were still in Plan B, and there were some sort of limited lockdown measures. So I don't think that the year to September 22 is a full clean year of normal face-to-face activity. However, the good news is that the field as a whole is back up to 17,000 cases. So we've recovered from the hit of lockdown. We've now shown 3% growth in the field since the pre-lockdown period. And it may well be that that number is still artificially slightly down because of no doubt quieter activity during the first half of that calendar year. Of the 17,000, online is still a very significant proportion. It has dropped, but it is still, as the next slide shows. Okay. So pre-pandemic, it was 2% down more. It was 80-something% during the pandemic. We're now a little over 60% on being done online. So I think mediation online is here to stay. And that's not just as evidenced by the data, as evidenced by everything that mediators are telling me. What we see is our own experience here at CEDR. It's not happening across the board. There are certain types of cases where there's still a strong preference for face-to-face. We're seeing some hybrids, hybrid situations where some aspects of the mediation process are being done online, and then some are done face-to-face. So, for example, re-mediation contact with parties is now more commonly being done online via Zoom than just by telephone. So there's more rapport building that's going on by the mediators in that early stage. We're also, a couple of days later, when we're talking about smaller claims, there is still quite a strong interest amongst mediators in doing those types of cases online. Not least because typically with those fixed fee schemes, they're not remunerated for travel time or travel expenses. So online becomes particularly attractive, as well as environmentally sensible thing to do in that context. So I think online is here to stay. So that's a significant change coming out. Has that had any impact on settlement rates? The answer is no. Settlement rates of mediation are still at 92%. So 72% settled on the day based on statistics reported by individual mediators, backed up by lawyers. And then there's about another 20% of cases which don't settle on the day, but settle reasonably soon thereafter, such that there's usable for the mediation to claim the credit. So I'm not here talking about cases which are deemed unsuccessful in mediation, but settle in a year's time on steps of court. That doesn't count as a result of mediation. But if a case settles with a week or two after the mediation day, mediators traditionally claim the credit for that. So success rate 92% unchanged, still obviously very high, very effective process. And some anecdotal evidence from mediators, which frankly supports my own perspective, which is that even those cases that do not officially settle, it's important to use the word settle, not success, because even the cases that don't settle significantly and frequently contribute value by narrowing the issues, by helping parties focus on what's important to them going forward and have a handle on their risk. So that's a benefit over and above, and frankly, it's slightly harder to track and to measure. Although we found if we dig into the process of mediation a little more, how much time is being spent. Typical mediation is now 15.8 hours for a typical day, typical case rather. That is about 8% more than 2 years ago, with the increase coming pretty much in the sort of preparation phase and a little bit in the follow-up. I don't want to read too much into that data yet, because it may well be that last year's data was slightly depressed because of the effect of online, possibly also because there was some perspective that 2 years ago during the pandemic, although mediation was happening, it tended to be the more straightforward, simpler cases, which were still going through to mediation. And there was certainly a tendency that we saw amongst lawyers that cases which were complex, big ticket, there was a tendency for let's just wait 6 months and see where we get to, and then maybe we'll be getting there. So I think the population of the cases may have shifted slightly, but I think it's now certainly happening. We also asked mediators to talk about whether there have been any changes in the process of things that happened during mediation. You'll see we asked about pre-mediation contact with parties and lawyers, pre-mediation submissions, and also meetings, joint meetings, meetings with lawyers only, meetings with clients only. We asked both lawyers and mediators, were there any changes in the popularity of those approaches? Secondly, were there any changes in the effectiveness of those approaches? These slides are a little bit difficult to understand, to interpret. So the way we asked people this question, you had there was a range of answers you could give that ranged from -2 to significant decrease, 0 is no change, +2 significant increase. So anything positive and getting closer to +2 is a significant move in the more direction. Anything negative, significant move to less. So I've got to ring around a couple of things to highlight for you. Pre-mediation contact, interesting. So mediators are certainly reporting that there is more of it happening, but for reasons which I don't entirely understand, they are suggesting that it is less effective. Now, whether that's because it's become a bit ritualistic, maybe because maybe they're spending too much time talking with lawyers rather than clients, or maybe they're letting people, maybe they're just letting people tell the mediator what a good case they've got. And the mediator is not getting much out of that because that's one of the things they know already. So I'm not quite sure. It's probably worth something we will try to dig into more as to what the substance of those pre-mediation conversations is. The other one, which is quite interesting, is views about pre-mediation submissions that largely complies to pleadings. Frankly, that's always been one of my bugbears as a mediator. I love pleadings. Again, it's just recycling what we already know. It's not really helping me move forward, me understand what's really important, what's going on here. But mediators say that there's more of it happening, and maybe it's even slightly more effective than it used to be. However, lawyers have a different view. They would like to see, they are saying that there is less of that, which is something I personally would endorse. But I mean, again, I'm interested in the mismatch of perspectives between the mediators. I'm a mediator. I'm always interested in mismatch perspectives. That's what we do, isn't it? So it's pointing out I don't really have an answer or an explanation for it, but it's what the data tells us. The next thing I'm moving on that I wanted to look into was mediator demographics. We traditionally ask questions about gender, age, ethnicity, and professional background. So in terms of these demographics, female mediators. In the early days of mediation, there were not a lot of female mediators. There's been a significant upsurge, obviously driven by more and more women coming into the profession through starting the training. So when you look at the profile of the profession, there's a much higher female representation in the lower and middle ranks, And then slowly some are now moving up the ladder. But it's still, because it's a relatively recent phenomenon, there's much more high proportion at base of the pyramid. But overall, we've now reached a position where 37% of our mediators are female, which is on par with Law Society statistics on law firm partners. That's slightly ahead. So it feels like in gender terms, the mediation profession is getting there. On ethnicity, probably not. Law Society, which is again is our main comparator, has 17% of its members come from ethnic minorities. Mediator respondents at the moment, 8%. So I know last time around we did quite a lot of work about diversity and identify challenges and attitudes. So there are campaigns afoot to start to address that issue. To be honest, it's too premature for me to go back and re-audit that type of number to get the attitudes. It's not much would have changed in a 2-year period, but there's still more work to be done, I think, on that topic. The age profile is an interesting one. Compared to an average law firm partner who is 52, the average male mediator is 63, which is significantly older. The average female mediator is 54, which is not a million miles away from law firm partners. I think that tells us something about, again, the historic antecedents question, rather than what's sort of happening. It doesn't tell us much about who's coming into the field now. It tells us who's been in the field for some time. More positively, I think 41% of our respondents are aged under 50. So there are a lot of clear signs of next generations coming into the field, getting training, starting to get started with their careers. They haven't reached the top yet, but they're coming. So again, a positive sign in terms of the take-up in the field, interested in training. Yeah. So the other thing we asked about was professional background. There's always been a debate between, or dispute almost, about the precedence of lawyer mediators versus non-lawyer mediators. And in particular, some of the non-lawyer mediators, like myself, have always got a bit agitated about this one. There has been a historic tendency for the non-lawyer mediators to be increasing in their proportion field. Reasons, again, which I'm not entirely clear about, it looks like that trend has been reversed in this latest audit. So we have a higher proportion of lawyer mediators than we've seen in the past, both amongst the population as a whole and amongst the advanced mediator group. I've done some thinking about why this might be, and bearing in mind also that particularly the advanced mediator group, it takes a number of years to be advanced. So it's not like suddenly a whole bunch of new lawyer mediators suddenly land in the advanced camp. They've either been there. So this is more about change and who is staying and who is moving on. The best art theory I've come up with is that this has something to do with the pandemic, something about possibly lawyer mediators' careers have been slightly more resilient, or they bounce back more quickly from lockdown. I don't know for sure, that's just my personal theory.
Graham, just as a quick question on that, how are you defining advanced mediators and full-time mediators on this slide?
Advanced mediators are basically people who say they have a lot of experience.
Okay.
So it's one of the early questions in demographics we ask you is, have you any experience as a lead mediator? Have you got a lot? So advanced is I claim to be experienced.
Yeah.
So it's advanced in terms of volume, I suppose it's fair to say.
Yeah.
Full-time mediator again is how do you describe yourself? What is your profession? So one of the options is I'm a full-time mediator. Another is I'm a full-time mediator and a lawyer. I'm a full-time mediator and not a lawyer. So that's how I identified that. It's fair to say, however, that when I dug into the full-time mediator crowd, a few as you'll see, there's about 65% say that that's what they are now, which is not significantly changed from last time. Should we say people have different interpretations of what full-time means? So there's quite a few people out there who say, tell me that they're full-time mediators, but they say they're doing like 10 cases a year. Now, perhaps that is full, perhaps that's full-time working for them. It's not quite what I understand by full-time working. It works for them. So there are different views about that. Overall, for those people who are not full-time mediators, one of the questions we asked this time was, so what percentage of your career, your professional life, are you spending doing mediation work? And the answer was just under 20%. That's for the non-full-time crowd. So there is still a significant portion of people out there who are doing mediation as an adjunct for the main profession still. I think we all know the reasons why that can be. It can be just it's an interest and that's what they wish to do. It may be that they are hoping to transition. Just there's a whole bunch of different reasons why it could be. So it's still a little bit of a mixed profession in terms of the backgrounds of people and the way that they are approaching the field. Now we move on to money. So we always ask mediators, I've done this right from the beginning. So what would your typical fees be for a typical one-day mediation, if there's such a thing? They have options of fee bands. And as you'll see from the slide, there are significant, the majority of mediators are somewhere in that range of between £500 and £4,000. So there's a pretty diverse range. However, there are many people who are charging significantly more than that, up to and including a few who are now charging more than £10,000 for typical one-day mediation. Now, it may be that these people are doing typical one-day mediations, which are mega cases. I don't know, but there's a significant divergence of the practice and experience going on in the charge out rate. However, it's probably fair to say that these rates have not materially changed over the years. So the next slide tries to average this all down. So I think I make a split between advanced mediators, the experienced mediators, and the others. So for on this slide called junior mediators, the less experienced mediators, their average fee for a typical one-day case works out about £1,781. The good news is that's 20% up on a couple of years ago. But as you see from the graph, it's not exactly varied an awful lot over the years. For advanced mediators, the average charging rate is significantly more at £3,893. Again, there's been a little bit more variation over the years, but it's been up and down. And this year, that figure is about 8% down. Again, I don't have any science to explain that. That may be the impact of online. It may just be a little bit of statistical knowledge because the sample base is slightly different from last time. We'll have to see what happens next time. Well, it's probably worth saying the 2020 figure struck me slightly high in retrospect. So perhaps it's just a slight correction of an error or a variance from last time around.
And just going to ask you a question about this. This is on a civil and commercial case, not through a scheme.
Correct.
So just a standard, anyone would be on.
Typical standard one-day case.
Sure. Thank you. So it's not influenced by people who scheme.
Not influenced by schemes.
Great.
So that's the sort of state of the nation as to where we are. And then we move on to talk about mandatory mediation and how the field looks. And we start here from a recognition that the government is talking about introducing automatic referral to mediation for cases valued up to £10,000. They are like to go to the HMCTS Small Claims Mediation Service. So other than the fine example that sets, it probably won't directly bring additional work for the mediation profession at large. However, it may be that example will spill over into the next value of cases, between the 10,000 and 25,000. In addition, hopefully, it may be that there is a second wave of referral for those types of cases, in which case the question is going to be, can the mediation profession step up to handle that load? So the first thing I wanted to do was to find out how much spare capacity there was within the mediation field at the present time. And the answer is there is quite a bit. This bar chart, basically we asked every single person, if you could have as much, well, if you could eat as much as you want, how many days a year would you be prepared to commit to taking on additional sub £25,000 cases? And we had a whole range of answers. Perhaps not unsurprisingly, many mediators tend to latch on the round numbers. So that's why there are peaks of 50, 100, 150. So we're all human, really.
Yes.
But overall, that chart demonstrates that there is a lot of willingness, a lot of capacity. It works out on average of about 80 to 83 cases, so extra days availability per person they'd be prepared to make available to do this type of work if it was offered. You multiply that by the number of members, number of registered mediators within the CMC, which, let's face it, is not the entire mediation population, decent piece of it though. And that gets you to 54,000 available days. That's equivalent to 245 mediator years. Conclusion, bring it on. The profession can handle it. There is far and away sufficient capacity within the field to take on the challenge of additional mandatory mediation if it's offered. Of course, there's no point asking people about their availability unless you also ask about money. So I also asked them, so assuming this was available, how much money would you want to make from it? So what would your daily income target be? I got the incredibly wide range of responses. There seemed to be a few people at the 10,000 mark who still thought £10,000 was a good answer. So what I've tried to do here is to break this down into, and they were distorting the arithmetic average. So what I want to do is I've broken this down for you into quartiles. So on my whole respondent group, there are 25% of that group who are looking for an income target of 460. So everybody would do it for that amount. If we need 50% of the mediators, it would be 1216. If you want 75% of the mediator group, £2,100. And after that, you start to get into the fourth quartile group with probably away with a fair issue. It's not now. So just ignore that. The other question I asked was, would you be prepared to work on a fixed fee basis? 83% of mediators would be prepared to work on a fixed fee basis, as opposed to charging on an hourly rate. What type of hourly rate would you look to have embedded within the fixed fee? £185 an hour. That works out at £1,480 now, 8 hour S. Those numbers out without any real insights to work this. Well, I think that is consistent with what mediators tell me they are currently charging on lower value cases. Whether it works in terms of the context of plans for the future, I don't know. But it's out there. That's what mediators say. Were there any other considerations for mediators who were contemplating taking on this type of work? Did they have any other doubts, any other issues? And there were two that were mentioned. One is this one on the slide. I mentioned already. Am I going to get paid for my travel time? Am I going to get reimbursed my travel costs? If not, I'd much rather do it online. Makes sense. So that point was made by a number of mediators. The other point that came up is particularly encapsulated in this one quote. This is for one individual. The point that's being made here is that particularly with lower value cases and less sophisticated parties, possibly litigants in person rather than professional, the whole logistics task can become more significant. So mediators are saying, well, who's going to look after the admin? I'm not sure I want to do that myself. If there was an administrator for this service, much more interested, much more active opportunity. Because many people see the admin side as being disproportionate to the fees are paid. So there's that, again, some additional factor for mediators contemplating whether or not they really want to get into this type of work. That alludes bells. That alludes to the impact of litigants in person. So we also specifically asked mediators, what was their experience of litigants in person? Litigants have a good understanding of the legal issues involved in their case, or a good understanding of the commercial issues involved in their case. How often do you see that? Was the key question that was asked. And similarly, how often are litigants in person able to represent themselves effectively? Those three simply in red. The answer is not very often. between 20 and 30% of the LIPs have a good understanding of their case, legal issues, and they can represent themselves effectively. It's fair to say that as the case values go up, their performance gets better, but there's still significant shortcomings, at least in mediators' perceptions of parties' abilities. Perhaps as a consequence, next one down below the red thing, 60% of occasions, mediators are being asked to express their opinions on the merits of cases. So parties are obviously not understanding the role of the mediator. Having said all of that, you look at the settlement rates down the bottom, only about half of cases involving litigants in person are hard to settle or take longer to settle. So that is the frequency of the problem is not matched by the frequency of the outcome. So we're seeing that, in other words, on 50% of all cases where mediators experience that parties have challenges, that is not having an impact on the outcome of the case. No doubt because mediators are able to handle it. However, having put that gloss on it, these are not great numbers. And it's really fair to say they are not inconsistent with the HMCD's findings in relation to small claims mediation service, where I think the statistics in the assessment say that between 15 and 21% only of parties who are approached about going to mediation with that service actually take it up, and then only 50 to 55% of those cases settle. Now, to be fair, it's only a 1 hour mediation, and you don't get a vast amount of information trying to persuade you. You just get some written material. But what it does say to me is that there is a desperate need for much more education. So if we're really going to get seriously into the field of litigants in person, non-represented parties, there needs to be a fairly significant educational effort to go alongside the administrative effort. Make sure that people understand exactly what the rules of the game are, what they can do to advance their own, to act in their own best interests, and what they can expect from a mediator and what they cannot expect from a mediator. So it's an additional challenge that needs to be picked up somewhere in the system. Other issues which have been talked about in the context of promotion of mediation, and again, this was something which was raised early on in the context of mandatory mediation. There's long been a sort of criticism of the mediation field, mainly coming from the old-fashioned arbitration community. But of course, the problem with mediation is that you never get a binding settlement agreement because you can't enforce it other than through a contract. And somehow it's got this weight. So we asked mediators and we asked lawyers, so is this a problem in real life? And basically the answer is no, not really. Everybody's seen 1 or 2 issues about enforcement or compliance with settlement agreements, but they tend to be of the defendant has agreed to make a payment and then suddenly discovers he hasn't got the money. Well, whatever the process was, that's still going to be a problem. So in terms of people, there are occasionally people who seek to renege on agreements, such as buyer's remorse. I get some of them at CEDR because they tend to be wrapped up in the whole mediation was a conspiracy between the mediator and my opponent. Get that quite a lot, actually. But in the real world, enforcement issues are rare. And the general perspective of the mediators really was that usually a diligent mediator can knock it down, get full buy-in to a settlement agreement such that there is no real worry about compliance. It's about one of the mediators actually put it in the comments to the audit. It's about, I'm not going to let this slide if it is not an enforceable settlement agreement. It's my job to make sure that people are really bought in and that this deal is going to stick. And as far as they're concerned, the mediation isn't done until they are happy that that is one of the things that they've achieved. That makes sense. But as I said, it's a bit of a non-issue, so it's been a bit of a stick to beat it with over the years. I don't think it's irrelevant. Finally, on mandatory mediation, one of the additional queries that has come up has been a discussion about regulation of the field. It's been talked about in the audit for a long time. It's particularly relevant now. I suppose the question is if the government or the judiciary are going to maintain mediation, are they happy to mandate referral to a totally unregulated or self-regulated profession, or is there a stronger need? So should there be regulation of the field? 88% of all mediators said yes, there should be. Frankly, that's not surprising because that's the type of statistic we've been seeing for quite a few years now. Not quite such support from lawyers, but still 76% of them support me. So I think the point is made. I think the debate is probably over on that one. Who should be it is a more interesting question. Mediators offer a range of options, including a new body or somebody else. You can write in whoever you thought should be the mediator, should be the regulator. 82% are perfectly happy for it to be the civil mediator. 75% of lawyers are happy for the CMC to be the regulator. There was no real push for anybody else. A couple of mentions here and there. A couple of people obviously don't like the CMC and like it. In essence, the overwhelming support was for the CMC. I should say, as a digression, particularly for those of you from the CMC, there was a slight oddity because one of the questions I asked mediators was who trained you, who accredited you? 20% of all respondents claim to be trained and accredited by the CMC. That can't be true. In other words, there is an issue. People are misunderstanding registered mediator versus accredited mediator. So the people may need to do a little bit of work about terminology.
Yeah.
So that's pretty much it in terms of the findings. But then most traditional, we pull it all together with a sort of benefit to society slide. So total value of cases mediated in the year, in terms of matters of issue, 20 billion now is the figure. That means that since the profession started in 1990, we've now mediated 195 billions worth of cases. In terms of savings to business, in terms of not just reduced legal fees, but reduced distraction, management time, damage to relationships, all the other things which are part of the cost of conflict. Annually, we save business 5.9 billion. And since then, the type on the slide should have said in 1990, we saved 50 billion. In comparison to that 5.9 billion, our profession's annual fee income works out at about 65 million. I've checked this maths a number of times. The return on investment is 9,100%. I keep checking it because that just strikes me as unbelievable. But that's what that maths says. So there is a huge benefit to society in the mediation field. However, having said that, we're doing 17,000 cases a year. How many cases are going through the civil justice system? So my colleague James South calculated that there are 247,000 contested civil law cases going through the courts every year. So at 17,000, we're barely touching the surface still. So there is still a lot of opportunity to go. So the field has come a long way. It's well established in the mainstream. It's a grown-up profession that is delivering huge value. But the potential to do much more, the opportunity to do much more, is still out there. Which is why this audit will know it's still going for us another 20 years. It'll be me, not for sure, but we'll keep on going.
Brilliant.
That's it. Thank you very much. Happy to answer any questions.
Well, thank you very much, Graham. And just so we will be taking some questions. I would just sort of remind you, if you are online, to please submit your questions in the chat, and we'll be able to take some of those as well. But also for people in person, I can see we've got a few questions. I've just got a couple of questions just for you. So if you were sort of taking then your biggest, I don't know, 3 things that you're taking away from this audit, what would they be, Graham?
One, we have recovered from the pandemic, albeit changed because online is now part of it. 2, we are delivering huge value to society already.
Yep.
3, well, we still haven't touched the surface. There's still a long way to go. There's a need, but similarly, there is already a capability to do that.
Okay. And just as a sort of a follow-up question, if you were sort of looking forward to the 11th mediation audit in 2 years' time, so what do you sort of see as being the changes for the mediation profession potentially that are coming? Is there anything that you're sort of seeing from this that you're interested to track?
Two things. One, I'll be interested in revisiting diversity
Yeah,
that was last looked at 2 years ago, just to see whether there's any change in that. Now that we've talked about it, we should
Sure.
play. So we can start seeing some fruits of this. Secondly, since we've talked a lot this year about lower value cases, I'd like to see signs of significant progress in that area as well.
right. So sort of diversity and also sort of seeing the changing cases as to what happened with the sort of increase of that.
Growth.
Yes. Right. And are you seeing, I mean, you obviously looked at sort of who the mediators are. Are you seeing any change in sort of who the mediators are in this?
Early signs. I have there's a little bit of an impression rather than direct scientific knowledge. I have an impression that some of the people who were the heaviest of hitters are still busy, but not as busy as they used to be.
Okay.
And similarly, there are some new people starting to stick their head above the parapet and start to become more established and starting to get more. So there is a gradual change. It's still very slow.
Okay, so that's something that we will be tracking going forward and sort of seeing what we do. As sort of the National Lottery said, it could be you, you're a mediator out there. I know we had some questions. I can see, Nicholas, did you have a question that you wanted to raise? And would you mind sort of introducing who you are as well?
All right, Nicholas Fournier, I'm deputy chair for the CMC. I'm so glad to have seen what you have discovered about the CMC planning strategy, an important role. No, I just wanted to ask a very technical question. The savings to business, I mean, here, how do you assess that?
Can I just repeat your question just for the audio?
Yes,
So just to say that, so we had a question from Nicholas Fournier, who's the deputy chair of the CMC, I hope I got that right, who is also a mediator, who was asking about the savings for business, specifically how you've managed to calculate these savings.
Okay, it's by bringing together a number of different research findings. So at CEDR, we track literally every single mediation. What mediators report was what legal fees to date, what are the management time to date, how much legal time has been saved because this case is now settled, how much management time has been saved because this case has been settled. So that's one piece of evidence. I've got evidence about how much is spent on litigation generally. And then in terms of the non-monetary measures, I've also in the past done surveys on the non-monetary costs of conflict. In other words, the damage relationships, distraction factors. And it's possible to come up with a multiple almost. So the answer to your question, Nicholas, is by multiplying a whole bunch of different numbers together, each one of which individually has been validated by research at some point in the past. Thank you.
Brilliant. Do we have any other questions from anyone in the audience here or online? Do we have a question online?
Yeah, there's a couple of questions online. Again, if you can repeat what I'm saying, so
Yeah.
they can hear it at home. So one of the points about litigants in person, one mediator colleague said it's very helpful to have because litigants in person actually ask about enforcement stats and kind of if they're at a disadvantage. So it's helpful to have that. Another question asking about the range. So was there quite a range or was it kind of fairly well clustered in terms of some litigants in person being fairly well versed and some being quite lost and at sea?
So I think we possibly will have had that on the audio, but just to repeat it for everyone, we are asking about litigants in person specifically and what their your understanding, Graham, from sort of diving into the numbers. What were the experiences? Were there any sort of qualitative experiences as well as quantitative in response to how people sort of reacted and dealt with litigants in person, or worked with litigants in person in the cases?
I don't think the survey really goes that far to answer the question, because the question I actually asked was, looking at your practice as a whole, whenever you've had litigants in person, how frequently do you experience this particular situation? And so it's a sort of, tick one of 3 boxes. Rarely, never, occasionally, frequently, always. So I never asked any individual to give me a range of the extremities. So each person has given me their perspective in terms of their average experience.
Yeah. And it's an interesting question, actually, in relation to thinking about one of the comments that was raised about having additional admin time of encouraging people to go to mediation if we're thinking about mandatory mediation as well. And sort of using those statistics, actually do get asked people about enforcement, do get asked about, is this going to work? There's a lot about, for most litigants in person, this is going to be their first rodeo of doing this. How do you do that? So to what extent actually using sort of statistics from the audit can be helpful just in sort of reassuring people as well as sort of showing the power of mediation.
I think as mediators, we talk about normalising things, don't we? I think
Yeah.
it's important to be able to normalise some of the feelings that people who are not familiar with this situation have.
Would you like mediators to be more confident with this talking about statistics?
I think they need to have it in their toolkit. I'm not going to say that mediators are not confident already. They may not have had the data to use.
Yeah.
But I think what they do definitely need, though, is more backup resource material.
Okay.
Because it's one thing as a mediator and sell my services to you.
Yeah.
I'm going to tell you the mediation script. You don't worry about it. It's another thing if I produce some evidence from somebody else.
Yeah. So objective.
Yeah.
Do we have any other questions? I can see we've got online in person. I will come to the one in person first, actually. Could I ask you if you would say who you are?
Sure, Andrew Hildebrand, and I'm a mediator. And I've got a question from something I saw on the screen, but it might be that I need to go to Specsavers. But I thought it said in relation to, I found it surprising, in relation to early joint meetings, that popularity with lawyers was 0.0%. And I didn't know if that was right, and also what they thought the effectiveness rate was, and what the corresponding rates were from mediators. And if there is a disparity, whether that means we're not giving people what they want, or we have to redesign something to be more effective.
Okay. So
just to say, I think everyone heard that, but just to clarify, this is specifically looking from Andrew Hildebrand at lawyer attitudes to pre-mediation contact and sort of
No, actually to on the day to an early joint session.
Yeah.
I think, Andrew, you probably interpreted the slide slightly differently from the way I meant. So the way this survey worked was 0 does not mean not effective. 0 means no change in the last couple of years. So it's about change rather than about. Curious, just what is your view about these things?
So there's nothing more than that.
It's nothing more than that. No, so the level of activity is it is 0, and it's consistent with the way it's been. Because I would agree with you on that. Yes.
We have a question online.
There's quite a few questions online, and apparently I'm sitting under a microphone so they can hear me at home very well.
Great. This makes my job easier.
So one of the questions is from Roger Levitt, is asking how do we think the audit will work, which we might not have the answer to. How do we think the audit will be viewed by dispute resolution professionals, i.e. solicitors, litigators, by the judiciary and by the Ministry of Justice? So that might not be one that we can answer. I don't know if I'll give all the questions at once and then you can kind of pick them as you go. There's another question from Janine McDonald about what information, or did you pick up anything specifically relating to workplace disputes in the research? And then finally, there's another question on the capacity. Did the mediators, when saying that they would be willing to spend the work on these smaller claims, did they indicate how many they might be able to do in a day? So those were the 3 points. How do we think it will be received? Anything about workplace and number of cases that might happen in a day, or people might be willing to do in a day?
Okay. So in terms of the first, how would we be received? I'd like it to be received as providing additional endorsement, additional evidence in support of mediation. I don't think there's anything in here which is threatening to anybody's interests. So I think as an additional tool to persuade others I think I'd like to think it's very helpful. I'm not going to speak to the Ministry of Justice. I'm not going to speak to the judiciary. I'll ask Deb Sarah to say something later on.
Well,
you may not want to.
I'll say that now, that's helpful about that. I think that from the point of view of the judiciary, I think that it will be considered to be very, very interesting. And from my perspective, as head of ADR or whatever you like to call me, I think it's an extremely useful tool, and I shall be definitely making use of it. And that is making use of it in relation to a culture change and a way of thinking. And there's a huge amount of work to do there. In relation to the MOJ, of course, I do not speak for them, and I have no real idea, but I have a tiny little chink of thought about that, which is, I think that at the moment they are very interested in value to be gained from mediation. And therefore, this sort of information which is up on the screen at the moment, I think they will find very interesting. I think they'll also find, I want to say again, I don't know, and I'm not speaking for them, but I also think they'll find your information about additional capacity very interesting.
Thank you for that. I mean, I agree with that, particularly since it's the important point about the audit is that although I'm the author, this is not me talking. All I'm doing is reporting what a significant number of mediators connectedly have expressed in terms of their views and their availability and their increased interest. So this is sort of just what that is. So I'd like to think it has more weight for that reason than just me sitting here as director of CEDR telling you stuff. It's better than that. What was the other question about workplace? One of the things I did ask mediators, commercial mediators, whether they were also doing other types of activity, and quite significantly do report workplace cases that are doing as part of a sort of portfolio. Much more workplace than, for example, family or community. There's not so many people who are doing both of those as well as commercial.
We should probably say though on family and community that they are distinct groups
and we do not target the survey to that particular audience. So we don't, by definition, get a response rate. We may get a better response rate from the workplace community because it's more integrated in the CMC community. But the survey did not really show significant changes in terms of activity levels, not since a couple of years ago. But again, we're in strange times. So the world 2 years ago and now even is still distorted, probably even more so in the workplace because it's influenced by things such as whether we're in the office or not.
And you had a third question as well, I think.
Yeah, the third one was just, was there any indication how many time limited small claims people might be able to do in a day?
Nobody expressed a view on that. To some extent, I avoided the question by asking them their availability in terms of days. However, another question I did ask, which I didn't mention, was I did ask them, so for a typical sub £10,000 case, how long do you currently spend? And how much you typically charge? For a typical sub £10,000 case, mediators reported that they were spending about 5 hours. Now that's quite a lot, particularly in the context of the small claims service, which is doing 1 hour. So I don't know what the view is as to which be about the type of mediation required, the nature of the economic arrangements which are put in place. And well, of course, it's slightly academic, of course, because mediators probably won't be invited to touch those cases. They go to the small claims service. But my instinct is what we're talking about here is not going to be a number of cases. We may get to a situation of time limited. Those of us who have been around for years will remember doing work in the London County Court, where you turn up at 4:30 and the security guard will throw you out at 7:30. So most of us learn that's what we learn our stripes doing that type of work, sort of settling off the street lamp. So it can be done in 3 hours. We've all been trained to do that. I can't really express an opinion further than that, I'm afraid, at this stage.
Okay. Good. Do we have any other questions from anyone in the room? I see actually a few now. So actually,
I do have a question that may move slightly away from stats, but you mentioned diversity of the mission population. My question is, from our point of view, the diverse people we have here in terms of profession, mediators, lawyers, judiciary, what can we do to facilitate the development of diversity in the mediation field? It is a question, I'm not talking to Frederick, I know you've been working on that for some time. What can we do? What actions can we take to facilitate a change in the demographics of mediation?
Happy to, I think it's a really useful one to talk about actually, and I think what's interesting about this is for some of us as a sector a little bit disappointing this year, and I think that particularly actually in regards to race and ethnicity, there is just not enough progress at all happening. But it is also a process that is changing. There is a lot of conversation happening about it. The CFC is having a lot of conversation about it. CEDR is lots of different providers. And I think it's something where it's continuing to do that. It's continuing to see how we can bring people into the field. It's continuing to see how we can provide observerships to people. It's continuing to see how we can encourage and train young mediators coming through. But also just to encourage everyone to share their experiences. There is no perfect target that we're trying to get to. It's not about having a quota or anything like that, I think, but it is something where people giving their support is really useful and valuable, and having role models there is something that we're looking at. So,
sure. A couple of years ago, 3 or 4 years ago now, so the CEDR Foundation did some research project to try to identify what were the barriers that were creating a lack of diversity in the field. And then identified a number of barriers, starting off from who comes forward to be trained in the first place, and then going through what happens to you after you've been accredited, how do you get started, how do you get onto panels, how do you get picked, how do you progress. So there was a series of milestones in the career that everybody faces where there were particular challenges. So that's and then when we picked up the audit 2 years ago, we then asked people's views about what can be done to address some of those things. There were quite a lot of useful ideas that came out about more active targeting, more active mentoring, many more examples for people to follow. I think we all collectively need to work in that. Frankly, it may be that mandatory mediation presents an opportunity. Because mandatory mediation will, if it goes well, it will widen up the population who have exposure to mediation. And if they have exposure to good mediation, that may open more people's ideas in society generally that mediation is a good thing, not just something to try, but even actually to. Well, in the old days, we always used to say, well, the best way to promote mediation we can get a storyline in Coronation Street. We never did. But perhaps this is the best thing.
And I think just to finish on this, at CEDR, we're still very obviously committed to doing this. It is in everything that we're doing. It is a long-term continuing commitment and something that we're working on. So I would just say, let's continue to have the conversation and what we're doing to work on it. It's, we want to do far more on that as well. I'm aware of time, and I know we have got a couple of questions. So actually, if it's possible to just pay the gentleman in the front row.
Yeah, sure. Jonathan Fingerhutter, non-lawyer mediator. In your questions, looking at awareness of mediation, and you touched on the point that those that go to mediation weren't necessarily all aware of what real mediation was. Did you ask about the broader awareness of mediation and in the great unwashed out there and so forth? And I normally say a storyline in EastEnders. Maybe that's our difference. You say one.
No, the answer is no, mainly because the only great unwashed by survey was the mediation.
No, but their perceptional frustrations that not enough people are aware of what mediation is and the benefits.
I didn't ask that question. Anecdotally, I would say there is a collective view amongst mediators that there isn't enough awareness. But on the other hand, if I was selling, I don't know, chocolate flavoured fish fingers, I'd probably say there's not enough interest in chocolate flavoured fish fingers. So by definition, because we're selling something, we perceive that the market doesn't get us. I think
it doesn't get the benefits.
Yes, we need to do something more scientific, I think, to have a campaign to get the message out.
Agree.
We've only got time to take one or two more questions.
Yeah, so Terry Reddiff, I'm also a mediator. Firstly, thank you, Graham, for doing this one and for the 9 previous ones. So thank you for that. But it was about mediators' aspirations for their fees, and you sort of gave us a breakdown of that. You also surveyed lawyers. Is there an indication from the lawyers in the survey that they're prepared to meet those aspirations? So we've got a supply side that says we want X, the demand side say we're prepared to pay X. No, didn't ask that question. Well, not least because the lawyers are not paying for another amount. It would be interesting, although if I was speaking to one of my sales and marketing colleagues, I'd say that price, should we say, if I've got quibbles about my price, that means I'm not doing a good enough job to persuade you of my value. So I think we need to meet the pricing challenge by being much clearer and upfront about the value. Because cost benefit analysis, it is a no-brainer really, but you've got to get the message across. Yeah.
Brilliant. I think that is probably coming to the end of the time, and it's good that we're ending on the money question. What we will be continuing sort of conversations on this. There will be lots more sort of podcasts, ways for people to ask questions as well, and sort of continue to talk to Graham, me, any of our senior colleagues about this, and sort of the community as well. As I said at the top of this, we will be releasing this tomorrow. So sending it to everyone who is here online and in person and directly. Will be all over social media if you're following us on all those channels. I do want to thank Graham for having done all of this research. This is a mammoth project that Graham does every 2 years, and for which we are immensely grateful for him doing it. So just to say thank you, Graham. And thank you to all my senior colleagues who are doing this. Lastly, sorry to end on a plug. We have on the 9th of March, a date for your diaries. We have a CEDR masterclass on trade union disputes. So we obviously have everyone here who managed to make it in during trade strike. But if you're wondering how you might negotiate with people in trade unions, mediate with them, we have 2 experts. We have Malcolm Curry and Gillian Carrick, who are both CEDR mediators, who are experts on trade union disputes, who will be talking. So that should be a date for your diaries to get involved in.
And reminding Gillian Carrick, workplace mediator.
She was Employment and Workplace Mediator of the Year. So great. So thank you to everyone online. Thank you very much for joining us.
And can I just creep in under the wire and to say that in relation to mandatory mediation, I'm not sure about whether it's going to be as good as Coronation Street, but if it does get taken up. But it just seems to me many of the things that have been said already, that if it's going to work and if it's also going to enhance the mediation space as a whole, which I think you would all like it to, then it is entirely dependent, I think, on education and a changing culture. And also, if it's going to work and at the lower end, it's going to be mostly litigants in person, then they have to be not only aware of mediation and how it works, but also have a better touch with what their case is about and its merits. You know, you're 60% asking mediator. So it's not just education about mediation, it's education about one's basic legal rights. And we have to move those pieces forwards if mandatory mediation is to be effective, it seems to me, at all, and whether it's going to create a spin-off for you all.
Thank you very much. It's Lady Justice Aspelin. Thank you. So thank you to everyone. I think that is the end. And so we will say goodbye to everyone online.